With the sounds of London rain in the background, you are back on the Legal Line with Dennis Kennelly and my special, very special guest, tax estate planning lawyer Dick Block from Woodland Hills. And we've been talking about estate planning generally. And before we get into the two vehicles that you can use if you want to plan your estate, namely a will or a trust, we mentioned earlier, Dick did, the gift tax. And this, I think, is one of the most misunderstood taxes levied by the federal government. Now, Dick, what exactly is a gift tax and when does it apply? And who pays it?
A gift tax is an excise tax imposed on the privilege of making a gift. There is an exclusion for gifts made to any person by any number of people in excess in the area of $13,000 a year. So, for example, Dennis, I can give you and each of the listeners $13,000 if I could afford it, and I would have to pay no federal tax. On the other hand, Dennis, if I took all that money and gave it to you, then everything in excess of the $13,000 that's exempted would be taxable.
Okay, now, is there a lifetime exemption?
There is. Well, the gift tax and the federal estate tax are what is called unified. So the gift tax exemption is $1.5 million, but it is unified with the federal estate tax. In other words, when the estate tax return is prepared, the gift taxes, the exempted gift taxes have to be factored, that are utilized, reduce the $5 million estate tax.
Because they're presumed to be what's called gifts causa mortis, in anticipation of death, correct?
Regardless, whether the gift is brought into the estate or not, that exemption still reduces the estate tax, dollar for dollar.
Okay, now, the recipient of a gift, let's say you gave it all to me, the many millions that you have. I would not pay taxes on it, but you would pay for the privilege of giving it to me. Is that the way it works? Are you there?
I am here. My answer was that is correct.
Okay, good. I missed it. Okay, now, there are two ways that Joe Citizen, namely Dennis Kennelly, or any of our listeners, can go about passing on the items that they have in their estate when they die. One is a will. Why don't you tell us what a will does?
A will is a document that operates at the time of death, and it transfers the decedent's property in accordance with the directions in the will. There are three kinds of wills, two of which are covered in the California Probate Code. The first is a written witnessed will that you would prepare with, for example, an attorney that designates what the property is and who it goes to or in what percentages. That will has to be witnessed by two people who are not beneficiaries, not interested in the estate, and who witness it at the same time and write their names as the same time as the testator or testatrix sign their name.
The testator is the
Testator is
person
the man-
making out the will, correct?
I'm sorry?
The testator is the person whose will it is.
Yes, it is the male person whose will it is. The testatrix is the female person whose will it is. That's old language. What is important in the witnessing of the will is that there is included the magic language. If the will is not witnessed and the witnesses do not sign under penalty of perjury that they have seen the testator or testatrix sign the will in their presence, and that he appears to be of sound mind and not subject to undue influence, then that will can be probated without any witness appearing to testify under oath that the will was properly signed. The second kind of will is what is called a holographic will. That is a will, again, that is witnessed, but is entirely in the decedent's handwriting.
Okay, so a holographic will requires a witness in California. Is that correct?
That is correct.
Just one or two?
Both, two.
Okay, and again, these individuals who are witnesses cannot be beneficiaries under the will.
That is again correct.
Good. Now you mentioned, and what's the third kind of will?
The third kind of will in legal terminology is a non-cupative will, and that is an oral will, and the kinds of property and the value of property it can dispose of is very limited. So it is very worthwhile to prepare a will that is in compliance, full compliance with the law in writing.
Okay, once again to our listeners, your questions are very important to us. We want to talk about what you want. You've got an opportunity to get one of the Los Angeles area's top estate planners and tax lawyers. He's actually been named a super lawyer, which is quite a designation. Richard Block. You can get a hold of us at area code 661-298-5487. That's 661-298-KHTS. So feel free, pick up the phone and give us a call. I'm now going to ask you, am I free in my will, for example, if I'm married and my wife and I aren't getting along, can I disinherit her?
That depends whether all the property is separate property or community property. To the extent it is community, no, you cannot. Also, a wife has, let's say the husband attempts to disinherit her. The wife has a right to take against the will and receive a portion of the estate by operation of law.
And what percentage is that?
I don't know that offhand. I'd have to check that.
Okay. Well, that's one good reason to go see Brother Block, and he will check it for you. It's a nice thing. Now, does the husband take a statutory share? Let's say the roles are reversed, and it's the wife that's got the money. Does the husband get the right to take against the will or not?
Yes.
Okay. So California is an equal opportunity state. It's not sexist. Which
not in that regard.
Exactly. So you mentioned a word probate. Let's say, and the person that administers this will is called the executor. And once again, it's the person whose will it is that names the executor. So let's say I'm the executor, and I find out, I go to Dick Block and find out that Dennis Kennelly died and left him as the executor of Kennelly's will. Can you, as the executor, just start doling out the property in accordance with the instructions of the will, or is there something else you got to do?
Well, you have to file a probate. In other words, all wills are subject to oversight by the California Probate Court. So you would go into court, file a probate, which would include a copy of the will, a list of the assets. You would have to prepare an inventory of the assets. That inventory would be reviewed by the probate appraiser, who gets paid for valuing the estate, and then the probate court, under the advice of the probate attorney, would instruct or approve how and when the distributions are to be made.
Okay, and this process can be somewhat time-consuming, can it?
It can be very time-consuming. It can be very frustrating. If documents are not prepared accurately or in accordance, as it may sometimes be, with the probate attorney's whims, you do it over again.
I know. I've got a client who was not smart enough to go to you, and the probate court has been tying up her money for like 18 months because the I's weren't properly dotted, the T's weren't properly crossed, and it's extremely frustrating to her because she has to pay the probate lawyer, and so she's broke, and there's a there's a $500,000 or $600,000 estate that's out there that could be keeping her at least in food and shelter, and she can't touch it. She can't. It's extremely frustrating. How do I, if I'm a live guy, if you will, and I want to avoid probate, what's the best way to do it? How can I eliminate this step?
Well, there are several reasons why people like to avoid probate. One is that you have to go through the court, you have the delays that you just mentioned, and also probate can be rather expensive. For example, under California law, probate fees, basic probate fees, are set by the statute. And so the statute requires that the estate pay the probate attorney 4% of the first $100,000. That's $4,000, and the executor gets paid an equivalent amount. So if you have a $100,000 estate, almost 10% right off the top is going to go to the individuals who have to deal with the court and the estate assets, and then you factor in the court-appointed appraiser's fee, et cetera, et cetera.
Plus, unless you're smart enough to put it in the will, you also wind up reimbursing the executor for the bond he's got to buy.
That is correct.
And that's not cheap, because that's the same price as a bail bond, right?
Correct. So what you want to do is to avoid a lot of these costs, a lot of these delays, having to deal with the court. And so the easiest approach is to utilize a trust. A trust is an entity that holds the assets. It is very valuable not only from a money-saving standpoint, but from an estate planning standpoint. An estate is set up and operates from the time it is created rather than just at the moment of death, so that the person who sets up the trust has an opportunity to see how it operates and to make sure that it accomplishes the purposes that he has in mind.
Okay, so for example, let's say you're a typical California family, and maybe you've got assets of $1.5 million, the largest percentage of which is in the house that you and your wife own as community property, or you and your husband own. And what happens? I assume that the first thing you do is put the house into the trust.
That is correct. Now, California cases have concluded that as long as the house is described in the trust, that is sufficient. However, to be much more certain, it is best to transfer of record the title to the house or any other property that is passing through the trust into the name of the trust at the county recorder's office.
Okay, and that's a heck of a lot better. You're obviously going to pay a fee to your lawyer to help you do this, or unless you try and figure out how to do it yourself. But it's a heck of a lot cheaper than 10% of the value of the estate, believe me.
That is correct.
And you get to control it. And the next thing that you do, I assume, is, let's say I've accumulated so much property. My wife's got some jewelry, I've got some paintings, and you want those to pass through the trust. I assume you simply put them on a list.
That is correct, and you attach it as a schedule to the trust.
Now, I've done all of this. I got my trust going, and let's say I buy a couple of new cars, and let's say I get a little lucky, and somebody gives both me and my wife, so it's community property, some stocks and bonds, which increase in value. Do they automatically go into the trust or not?
No, and that is very important, because if there is real estate or if there is other property in excess of $150,000, then that property, to be transferred into the trust, must go through probate. So it is important to stay current with your estate planner to make sure that all of the property that you want to transfer under the trust is, in fact, included in the trust.
Okay, and this is a wacky question, but I knew a gentleman who was a collector of wine, and he was very proud of his wine collection, and he had very specific ideas as to what happened to his wine collection after he died. He had probably a list of 100 people, and each of whom was to get particular bottles. Can that be accomplished through the trust?
Yes, very easily. But you don't need to include the easiest thing to do is to attach to the trust a list of who gets what. I guess the story that I want to relate here goes back to the will. Under California law, it is possible to incorporate into a will a document which has been prepared prior to the will. So, for example, if an individual goes out and acquires property after the date of the will, you could not simply go back and add that to the list, because that would result in the list not being limited to property which pre-existed the creation of the will.
Okay, well, that's important. That's really important. Now, the advantage of all of this is that if you do it right, you avoid probate. You avoid a lot of the expenses and delays of probate. Are these expensive to set up? I mean, I don't want to spend a small fortune to save the probate fees. Now, in a normal situation, if I came to you and I'm not a multi-millionaire and I have a normal estate, how much would it cost me to get a living trust set up?
I generally prepare an estate plan for the amount of $1,500. That includes the trust, whether it's a single individual or a husband and wife, 2 wills if it's a husband and wife, and a health care power for each, and a durable power of attorney for each. The durable power of attorney designates someone to deal with financial issues if the person setting up the trust, the settlor, is no longer capable, and the health care power designates someone to make health care decisions for the settlor if he is no longer capable of doing that, and the will picks up any property which has not been transferred to the trust, such as this after-acquired automobile, and transfers it into the trust, subject to the admonition that you better make sure that the property that passes by the will is not in excess of $150,000 in value.
Understood. How do they get a hold of you if they want to, our listeners?
My resume, if you will, is in my website, richardblocklaw.com. My telephone number is 818-716-1585. Just give me a call. I do not charge for an initial consultation in person or over the phone, and I'm always glad to talk and help if I can.
Okay, speaking of helping, we're going to help the station make some money and take a break, so we'll be back after these words. You are back on the Legal Line with Dennis Kennelly and my special guest, Dick Block, estate planning attorney extraordinaire. And I guess want to use this opportunity to just let Dick give us some words of wisdom. Mine would be on this subject that you would better, if you've got any money, any assets at all, and you want to control who gets what after you die, you better take some action. Because if you take no action, you're going to wind up with a result that you can't control. Dick, you have any final thoughts on the subject?
The importance of estate planning and making sure that the people you want to benefit by all the hard work you've done in accumulating property during your lifetime is illustrated by what I was taught by my trust and estate professor at law school.
At the Harvard Law School.
At the Harvard Law School. And what he said was that most people are concerned with avoiding taxes, but that's all wrong. What is important is making sure that the people you care for or you care about receive the benefit of your labors.
That's right, and you can't do it from the other side. Nobody's figured out a way yet. Although I do have a good friend that believes in the fact that you can't take it with you, but he's still looking into ways to send it on ahead. So he hasn't found any yet. So we got 3 minutes to go. I want to thank Dick Block. Dick, give your website again so people can get in touch with you.
richardblocklaw.com. block.com.
And Block is spelled O-C-K or O-C-H? O-C-H?
BLOCK.
Okay, the simple way. So if
Like
you want
a block of wood.
a block of wood, well, he's a block of great advice. Dick, I want to thank you for sharing your thoughts with us. It's been a pleasure having you, and we'll have you back in the future to talk about the other side of your practice and the other thing people don't want to talk about, income taxes and various other taxes that we all pay. So again, I want to thank you. I want to thank my engineer, Justin Powell, and I want to let you know, folks know, we delved a little bit away from our traditional area of employment and entertainment law today, but I hope you enjoyed it. The way to get in touch with me is go to my website, Dennis, D-E-N-N-I-S, Kennelly, Kennelly.com. I'll give you a free half hour on the phone and a consultation, and let's figure out if I can answer your question or find out an answer if I don't know it, and if we need to go any further, if you've got a case. And as I say, I represent both employers and employees. And employers, if you call in, the time to call me is before you get sued, because then I can do something about it and hopefully prevent the lawsuit. So it's DennisKennelly.com. And we're going to end the show as we did last week. We got a minute. And my beloved announcer, Justin Powell, also happens to be the station's sports director. He stumped me last week.
This I did.
Which rarely happens. Now I got one for him.
Let's do it.
Okay. Tom Brady, he succeeded when Drew Bledsoe got hurt with the New England Patriots. Tom Brady succeeded him, went in for him temporarily, and Bledsoe never got his job back. But what most people don't know is Tom Brady was a sixth-round draft choice, and there was a reason. He was not a starter at the University of Michigan, where he attended academic exercises. He was the second string. And my question to my beloved colleague my question is, who was the first-string quarterback for the Michigan Wolverines? And I think I got it.
Started at Michigan. Okay, it wasn't Chad Henne. That was too late.
No.
Oh, man. Was his Rick Mirer?
No, he was at Notre Dame.
He's at Notre Dame? Oh, okay. You got me on this one.
Drew Henson.
Oh, it was Drew Henson, and he played for the Yankees farm system. He played baseball.
He became a baseball player.
Oh my gosh, I knew that, Dennis. I knew that one.
You've been listening to On the Legal Line with Dennis Kennelly. The opinions and advice of Dennis Kennelly expressed on this show are not necessarily those of this station,
Go ahead.
management,
okay.
for advertisers.
I was a little confused. I heard the disclaimer. But, hey, it has been a pleasure talking with you today. I hope you got something out of it. Every time I talk to Dick Block, I get something out of it. Stay tuned. Next week we'll be talking employment law again, sexual harassment. We've got a number of potential guests lined up. So this has been On the Legal Line with Dennis Kennelly and our guest Dick Block, and we look forward to talking with you next week.